Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is Senior Associate from MBK Chapman, Sam Keel. Sam, good morning.
Morning, Mike. Good to be with you.
Good to have you here. So today, Sam, we're going to talk about something that affects every single HOA that I'm aware of in the state of California, and that's rules.
Absolutely.
Okay?
Yeah.
And when we talk about rules, I'm talking about the rules and regulations that every HOA I'm aware of has.
Mm-hmm.
And they can be rules about parking, rules about construction, rules about changes to your unit, rules about noise, rules about anything.
Mm-hmm.
How to use the pool, the hours of the pool, anything. Rules. That's what we're going to talk about today. Okay? HOA boards all over the state pass rules and enforce rules as a matter of course.
Mm-hmm.
Okay? And those rules can, they impose restrictions by definition because they tell a homeowner what they can and can't do and when they can and can't do it in some
Right.
cases.
Mm-hmm.
Okay. So that rulemaking authority is a big part of HOA life in general.
Mm-hmm.
And it's not always bad. Rules are good. Okay. Rules that are designed to maintain, a community aesthetic or to maintain the peace and harmony of a neighborhood.
Consistency, yeah.
Those are good rules.
Mm-hmm.
Okay. Rules only become bad if they serve no purpose or if they're enforced abusively or selectively.
Mm-hmm.
We're not going to focus today on the enforcement mechanisms at all.
Mm-hmm.
We've got other episodes where we talk about enforcement mechanisms. We talk about selective enforcement. We talk about hearings. We're not going to even touch on that today. Today, we're just going to talk about rules and rulemaking authority, where it comes from, and its limitations. That's it. That's today. Okay? Now, to begin with, as a primary beginning, which you must start at the beginning, is that HOA boards cannot adopt rules unless the governing documents give them that power.
Correct.
Now, truth be told, 98% of HOAs in California have
Mm-hmm.
that power. And that power would be found in CC&Rs, bylaws, or articles of incorporation. Now, I like using 99% because it's like saying almost always.
Mm-hmm.
99% of the time, it'll be in the CC&Rs. It just doesn't have to be. It can be in those other two documents. Today, when we're going to refer to the CC&Rs. It could be in one of the other two documents as well. But
Correct. Mm-hmm.
we're going to talk about the CC&Rs just so I don't have to say all three of those. And 99% of HOAs in California, somewhere in the CC&Rs, it'll give the board permission to promulgate rules. Now, if it doesn't, if it's completely silent, then the HOA cannot promulgate any rules at all, and the only limitations on people's rights and responsibilities are going to be those set forth in the actual governing documents that exist and nothing else. However, for most of today, we're going to assume that the power exists because it does almost universally. Okay? But the important part is it's got to be in there.
Yeah.
Now, there are a few exceptions to that requirement. That requirement being an HOA that doesn't have the express authority in their governing documents can't pass rules. There are a few exceptions.
Mm-hmm.
Okay? Now, why is this important? Well, Civil Code 4350, subsection B specifically, is the part that says rulemaking authority has to be found in these governing documents. Here's the exceptions. Okay, I'll give one and then you give me a couple, then I'll close out.
Sounds
because
good.
I think there's four.
Let's do it.
Okay?
Mm-hmm.
First exception is under Civil Code 4765. So what we're talking about is cases where an HOA that doesn't have rulemaking authority can still pass rules regarding a few items. The first one is architectural guidelines and application process from Civil Code 4765. And that's because if your governing documents are silent on the rules entirely, meaning the HOA doesn't have the power to promulgate them, but it does require homeowners to apply for permission to make changes to their property. In order to evaluate those applications, the board has to have some rules regarding its evaluation process. And so the statute says that the HOA, or it's implied very strongly, that the HOA can pass rules as to that issue. So that's an exception to our governing documents are silent as to rulemaking.
That's a big one. That's huge.
Okay. Give me another one.
Another one that's common and frequent and is one of the major exceptions is passing and adopting election rules under 5105.
Right. And that's because why?
That's because it's critical to the operation of HOAs in terms of
It's mandatory.
Mandatory. I mean, getting board of directors in place.
All
yeah.
HOAs have to have actual printed election rules. The statute, that one you cited, 5105, says that.
Exactly.
Meaning it doesn't matter if the governing documents.
It can't be something arbitrary. I mean, there needs to be consistency, transparency to the membership.
None of that matters.
So they know what they're looking at.
It's just the power to pass election rules. Give me another one.
Another one that's a big one is collections, lien enforcement, and foreclosures under 5730.
Okay. And tell me why that's the case.
Well, that's because everyone has an obligation to pay dues, and it's one of the major sources of funding for associations, and they need to be able to enforce that consistently throughout the membership.
Right. And to the extent that there are rules regarding that, they're allowed to impose those.
Exactly.
Part of that, because those collections, liens, and foreclosures are such draconian measures, there needs to be clarification on how that's used in addition to what the statute says. And then the last one is Civil Code 5905, and it relates to IDR, Internal Dispute Resolution. As you know, we've talked about in many episodes, IDR, when a homeowner requests it, is mandatory. Well, the HOA, through this statute, is obligated to have some rules in place regarding how IDRs are done. And as a result, it doesn't matter what the governing documents say. The statute says you got to have those. So those are the exceptions. Unless you fall into one of those four, if the governing documents don't say HOA can pass rules, then HOA can't. Now, as we said at the beginning, 99% of HOAs have that power in typically the CC&Rs. So for the rest of the show, we're going to assume that you have that power. Okay, you being the HOA. So let's assume now that rulemaking authority exists. That doesn't mean that the HOA can pass any rule it wants. No. The rule has to be, and we're going to talk about the statute in a minute, the rule has to still abide by or honor the governing documents, and it cannot violate federal, state, or local laws, and we'll get into that shortly, okay? So let's talk for a minute about what is governing documents, I guess, okay? Governing documents make up CC&Rs, bylaws, or the articles, and then like rules and regulations, architectural guidelines, if your HOA has any, election rules, all these other—
Any policies?
Any policies that have been properly passed are all part of governing documents. Now, according to Civil Code 4205, and I think 4350B, but 4205, there is a Davis-Sterling Act hierarchy to those governing documents. The top of the list is
the CC&Rs.
CC&Rs. Those trump anything lower, okay? In other words, to the extent there is a direct conflict between something in the CC&Rs and something in another governing document, the other governing document loses.
They're subordinate, absolutely.
Okay, subordinate. After CC&Rs comes articles of incorporation. Now, I've written extensively on this topic. For the vast majority of HOAs and homeowners, the articles are almost always 100% irrelevant to you. And so we don't think about them and we don't talk about them. I'm listing them only for accuracy's sake here, okay? Next comes the bylaws. So CC&Rs, articles, bylaws. The bylaws are sort of like, I like to use a baseball analogy because it seems to be a good fit. The little rule book that the umpires have to read, that's the bylaws.
It's really about governance.
That's right. It's about the actual governance of the association as opposed to a homeowner's obligations and rights vis-a-vis each other and vis-a-vis the HOA as a corporation. No, these are how is the corporation supposed to work or operate in terms of meetings and minutes and that sort of thing. That's the stuff you find in the bylaws. And then underneath the bylaws are the rest of the governing documents that are tied. And that's where we get into the rules and regulations, architectural guidelines, blah, blah, blah. Okay? Now, so on top of all of those, okay, so you have your CC&Rs, articles, bylaws, and everything else equal. On top of the CC&Rs sits federal, state, and local laws. In that order, Typically, federal law will override state law. State law will override local law, and local law overrides your governing documents. Okay? So you might have, for example, a rule that 100% complies with your governing documents, but violates a statute. We'll get into that later. That would be illegal, okay? Because law trumps.
Right.
Now, what's interesting about that order, and we'll get to this in a second, is, and remember, these different governing documents, they don't carry equal weight. They carry the weight based on the order they appeared.
Correct.
So, because we're not going to really talk about bylaws and articles today, we're going to talk about CC&Rs. Any other governing document that says anything that is conflicting with anything in the CC&Rs is going to be
null and void.
Null and void.
Yeah.
Okay? So, tell me, because we all know, and we've talked about this in other episodes, that CC&Rs are very hard to amend. Usually requires a supermajority. It's and a full-on election, right? It's a big deal. It's hard. So bad HOA boards have ways of trying to get around having to amend the CC&Rs. What's the most common way they would do that?
Well, the common way they do that is by way of rule changes and adoptions, where they bypass the required CC&R amendments. So essentially, the rules would be running afoul of provisions that are clearly stated and unambiguous in your CC&Rs. And we can give examples of that to the audience.
Before you give example, let me ask you a question. Let's say that your CC&Rs are, talk about setback requirements, but are silent about a rear, let's say your CC&Rs talk about a rear setback requirement, but are completely silent as to a side setback requirement.
Okay.
And the HOA has rules and regulation power. Could they pass a side setback requirement?
They could.
And that wouldn't conflict directly,
it would not,
would it?
Because it does not interfere with the rear setback requirement in your hypothetical.
Okay.
Now, if I may go one step beyond real quick, is they can also flesh it out, supplement it, or articulate clarity on what that rear setback requirement is, so long as it does not run afoul or conflict or contradict that provision.
So just because the CC&Rs say something doesn't mean that a rule can't flesh out that issue or talk more completely about that issue, or talk about something that the CC&Rs are silent on.
Exactly.
We're only talking about direct conflicts. Let me give you a good example.
Okay.
Because this happened in an HOA I used to live in. Okay. The CC&Rs specifically stated that it gave a list of vehicles that weren't allowed in the community. And it talked about RVs, and it talked about boats and trailers and that sort of thing. Okay. And it mentioned by name Sprinter vans.
Oh.
Okay. The rules, the board tried to later amend the rules or actually pass a rule that was going to allow Sprinter vans that weren't RV conversions. In other words, family passenger use Sprinter vans. Okay. That ran afoul of the law because the CC&Rs specifically said no Sprinter vans. They could not pass a rule that allowed Sprinter vans by name. Had the CC&Rs, like my current HOA, just talked about RVs, no RVs, recreational vehicles, such as campers and, RV conversion, stuff like that. Then they could pass a rule that said, no, Sprinter vans are okay as passenger vehicles, but are not okay if you include a bed or a kitchen or anything like that. Because what they're doing is saying, if you make it more like a RV, we're not allowing it. That would have been okay. But in the original scenario, in the old HOA, you couldn't do it because it specified no Sprinter vans, and the HOA was trying to say yes, Sprinter vans. Can't do it. Let's move on. Right? That's what we mean by direct conflict. Very good. Now, Civil Code 4360 imposes mandatory procedural requirements for new rules. So obviously we've got authority. We've talked about that. Our HOA has authority to pass rules. Our HOA can pass rules that don't conflict with a higher governing document. But there are now, how do you pass these rules? Okay, let's get to that now because that matters as much as anything else.
Absolutely.
There is a way to do it, and that's what's controlled under 4360. So 4360 sets forth a bunch of rules, and those rules include, for example, the 28-day comment period.
Yeah.
Okay. They include the So let's talk about the 28-day comment period. Tell me what that is.
So under 4360, the procedures outline that any proposed rule change or adoption before it goes into effect requires the board to share it with the association or with the membership, to be precise, give them 28 days to comment, express any concerns, objections that they want before it goes to the next step of...
Which is the meeting.
The meeting. There's an open meeting.
So there's a minimum, they can do more. There's a minimum 28-day comment period, which really is just, you can't set the meeting to effectuate and vote on the new rule unless you wait at least 28 days. That's really all that means, okay? During that time period, they have to submit a word-for-word version of the new rule.
Yeah.
Okay. Now, good HOAs will do it with a red line and show if it's a change in a rule, they can redline it. If it's a brand new rule, there's nothing to redline. You just here's the text. Here's the new rule that we want to pass. Whatever it says, it says. Okay. Now, and we're talking right now about non-emergencies. We're going to get to emergencies. There is a limited exception for it, what's called a true emergency, which gets rid of a lot of these procedures for obvious reasons. Got to be able to do that. So we're just talking about regular rule changes that aren't emergencies right now. Right. So you have the 28-day comment period. Now, then the meeting gets set sometime from the 28th day onward or 29th day onward. Okay. At that meeting, and that's an open meeting that homeowners can attend, not only must the board at that point vote on, okay, we've passed out this new rule, let's vote, let's pass it or not pass it. That's the vote that's going to occur out in the open. Not only do they have to do that, but they have to allow homeowners to briefly comment during that meeting. In other words, they have to allow the open forum. And typically, they usually make it a little bit longer than normal so they can flesh out any concerns. They have to allow homeowners to speak about the rule change. Do they have to listen to them? No. As long as they allow it, yeah, oh, thanks for sharing. Good. Let's vote. Oh, let's pass the rule, even though everybody said they hated it. No, they don't have to go with what the majority says. They can disregard what every homeowner says and pass the rule anyway if people are against it, or vice versa. Okay? A good HOA won't do that because they're supposed to represent what their people want, but they have the legal power to do that. Okay? But they have to allow that. Then they have to vote in the open. What's the next step in terms of timing?
Well, when they vote and adopt it at this open meeting, then they have 15 days to notify the membership. And remember, not everyone may attend this.
Most don't.
This open session meeting. So they have to notify the entire membership that that rule has now been adopted within 15 days of that open meeting where the vote occurred.
Exactly. And the rule doesn't become effective until the HOA delivers the notice, not the end of the 15 days.
Correct.
The rule goes into effect the second they post the notice or drop the notice in the mail or whatever is required under their governing documents to communicate this sort of thing.
Correct.
That's when the rule goes into effect. So although they have 15 days to tell everybody, when they tell them, that's when it goes into effect, the day they tell them, okay? However they tell them. Now, let's assume for a minute that the board wants to pass a rule on an emergency basis, okay? There is a narrow exception to the 28-day thing, the 15-day thing, all that. There's a narrow exception. And it is for what we call a true emergency. And that makes sense because you might not be able to wait 28 days and wait for people to comment and then have a meeting to vote on it. And now you've got like real damage, right? So there is a rule out there. It's in that same statute, 4360. And it says, okay, if there's a situation where there is an immediate threat to public health or safety or an immediate threat to a substantial economic loss or immediate threat of a substantial economic loss, then the board can pass a rule with no notice whatsoever. Okay? Just boom. It goes into effect immediately. Now, they have to notify the membership immediately of that emergency rule.
Yeah.
But it's in effect immediately, and there was no comment period. There was no open meeting. It was passed just on the basis of one of those factors: imminent threat of health or to somebody's health or safety, or imminent threat of substantial economic loss. That's it.
Right.
Now, that rule is not permanent, is it? What is the maximum, only the maximum time that rule can be in effect? No matter what the rule itself says, what's the maximum?
120 days.
That's it, 120 days. Now, it can be shorter. If the emergency rule says this emergency rule shall terminate in 30 days or 60 days, then it would be less than 120. But if it's silent, or if it says 2 years, doesn't matter, it's 120. At the end of on day 121, the rule is no longer in effect. It's not enforceable.
Correct.
Okay? Yeah. So this is not an end run around the notice period declaring an emergency. Also, if it isn't a imminent threat of health or safety or substantial economic loss, it won't pass. It won't be kosher, and it won't pass the smell test as to an emergency.
And after the expiration of the 120 days, if they wish to extend it,
they got to do it right.
Revert back to the normal standard procedures for rule adoption under 40.
And they got to start over. Exactly. They got to submit it and say, okay, this is our new rule.
28-day comment period, cannot run afoul of the CC&Rs.
What we just talked about. Okay? Now, let's say, because we said a minute ago when we talked about this process, let's say a bunch of people showed up at the meeting and used their time at the open forum to say, I hate this rule, it's stupid, it's wrong, it's unjust, whatever. Yeah. And homeowner after homeowner after homeowner was against this.
Yeah.
Almost unilaterally, the entire room. And the board nodded their head and listened and then voted unanimously to pass the rule anyway.
I've seen that happen countless times.
So have I.
Yeah.
I've seen both. Seen both happen. I've seen boards that have said, ooh, all right, we've miscalculated. We are going to table this right now and for further discussion, and we'll address this at a future time. Boards can do that. Good boards will do that. If it's overwhelming anti-rule, they will do that. But we've also seen where boards just go, we're dotting our I's, crossing our T's. We don't care what you say. We're doing what we want. And they can do that. However, homeowners do have a remedy.
Yeah.
Homeowners have a remedy under Civil Code 4365. And the 4365 is basically the veto. That's the homeowner veto to a new rule that was passed. And in order to kick the veto into gear, it is the same qualification that requires a recall vote. And that's basically 5% of the homeowners entitled to vote.
Signing a petition to veto.
Okay?
Yeah.
It's a veto petition. If 5% of the homeowners in that HOA sign that petition, then there must be a vote, an election, as to whether or not that rule needs to go bye-bye. In other words, are we overruling the board?
Exactly.
Okay? Now, once the members have turned in their sufficient threshold, 5% or more of the signatures, then that vote, that election must occur between 35 and 90 days from that time period. Can't be less than 35, but it can't be more than 90.
Correct.
So somewhere between 35 and 90 days after the petition's turned in, there has to be a formal yay or nay on the veto of that. Okay? And people vote, and all that's required to win
majority
the
of a
veto
quorum.
is a majority of a quorum.
Yeah.
To win the veto, to overturn your board, you just need a majority of a quorum. If your HOA has 100 people, 51 people show up, you need 26 people, you win. Okay? That's all it takes. All right. Now, assuming you have power to enforce rules, assuming that you've gone through all the proper steps, no veto has occurred, a rule has now been implemented. That doesn't mean the rule is enforceable. The rule still has to satisfy reasonableness standard under 4350. That's a code section we keep saying over and over today. The reasonableness standard is important. It's mandatory.
Critical, yeah.
Rules must be reasonable, which means they can't be arbitrary, capricious, or unfair, and they have to be, you have to be equally applied and all the other stuff we talk about in other episodes. Okay? Let's talk about an unreasonable rule.
Okay.
You talk to me about that. Give me an example. An unreasonable rule. Pets. Pets comes up a lot.
Okay, let's
we had one recently, didn't we?
Let's say a rule essentially being adopted by the board saying you cannot walk your dog in common areas. You have at all. You have to carry your dogs in the common areas, or you may not have dogs.
Or you have to drive them out.
Exactly.
Yeah.
Exactly. I mean, that's completely unreasonable.
Yeah, that's
it runs
insane.
afoul of countless other, public policy.
Right. So we have a statute okay, we have a statute that requires every person in California living in an HOA to have a fish, a dog, a cat, or a bird.
Yeah.
Okay. Those are specifically the pets that are mentioned in the statute. But we're talking about a dog today because people walk their dog. We have a situation now where a homeowner lives in a 55 plus community and their HOA has just passed a rule saying that no dog's feet can touch the common area. In other words, you either carry your dog or you have to drive them out of the community to walk them. We'll shut that down very quickly. That is on its face insane, idiotic, unreasonable, and no court would ever enforce that. And they will lose, okay? It is ridiculous. That is what we're talking about here. The rules have to make sense, okay? Yes, they have to be applied uniformly and all that other stuff, but they have to, at their very basic, make sense. They have to relate to a proper exercise of HOA power.
Right.
For example, here's another one. We had a case a few years ago where an HOA that provided, as part of its common area amenities or common amenities, provided internet service to everybody. Okay, it was part of your dues. So nobody had to pay Cox or whoever for their own high-speed internet.
Right.
It came with, you buy the house in that HOA, you get internet paid for by your HOA. Of course, you pay for it in terms of dues, but that's another issue.
Right.
Okay? And so because this HOA controlled, provided this as a common area amenity or common amenity, this HOA felt like it had authority to pass a rule saying that you cannot use the internet, like social media, to criticize them. Completely illegal. Completely subject to.
That's just.
If they tried suing to enforce that, there would be a very fast anti-slap.
That's
okay?
Asinine. Yeah.
Yeah. That's a great term. It's an asinine rule. Okay. We shut that down quicker than you could say Quidditch.
Yeah.
Okay. To borrow a line from Harry Potter. Okay. That's the sort of thing we're talking about here. The rules have to be reasonable on their face. They actually can't be arbitrary and capricious, and they can't be unreasonable. Okay. Now. Rules also can't run afoul of public policy. For example, there's California public policy regarding discrimination based on certain characteristics like race, gender, sexual orientation, religion, that sort of thing. So HOAs can't have rules that would be discriminatory against any of those protected classes.
Right.
They can't. Those are just violate public policy. Those are illegal on their face.
You can objectively enforce against, let's say, nuisances, but not
where
you're targeting
course.
Protected classes.
Okay. Yeah. In addition, they can't pass a rule that's unfairly burdensome on a particular group, even if it's not a protected class. For example, people with children.
Oh, yeah.
Okay.
It's a common one.
Let's say you have really nice floors in your high-rise condo. No strollers, stuff like that.
Yeah.
No, that's unreasonable. They can't do that.
Or a common one we encounter is children may not play in common areas.
Right. Well, that actually, I would say that would be under public policy, right?
Yeah.
Children not being able to play outdoors in the common area. In other words, no bikes, nobody can ride bikes anywhere in the community. No. Kids are allowed to play. There are federal and state laws that protect parents, that protect the right for kids to be kids. An HOA can't de facto pass rules that only affect families with kids. No, can't do that.
Right.
Okay? If there can be, if it follows the other laws, you can have communities that are designed not to have kids in them, for example, 55 and older, but that wouldn't stop kids from visiting grandparents, but it could stop them from living there per se, let's say. Okay?
Right.
But other than that, you can't do that.
No.
Okay? And so we see that. Maintenance and use restrictions, for example, that completely shift, let's say it's a condo complex and they shift completely the burden of maintenance, replacement, and repair of the roof onto the homeowners.
Yeah.
That's insane. That's not going to pass.
No.
Okay? And more importantly, HOA rules cannot override Davis Sterling Act, for example, state law. Okay?
Yeah.
So, good example, Civil Code 714 and 714.1. I don't care if any of your governing documents or rules, which are part of governing documents, say no solar panels. That runs afoul of 714, 714.1. Solar panels are protected by statute. Therefore, it doesn't matter what the rule says or the CC&R provision says, illegal, done. Okay. Civil Code 4715, owning a dog. We just talked about that in our example.
Right.
They can't ban pets. I don't care if they pass a rule saying no dogs allowed. Can't do it. Why? Because 4705 says you're allowed to have a dog, a bird, a cat, or a fish.
Right.
Okay.
They can pass rules regarding certain breeds, but not
And those have to be
outright.
reasonable.
Exactly.
And they can do weight restrictions or number of pets.
Right.
Subject, of course, to the reasonable accommodations and if it's a service animal, which are not considered pets and therefore wouldn't even apply. But that was another show which we did as well. Okay. Now, so those rules, we now know we can't override state law. We can't override public policy. Okay. Here's one we've seen. We used to see this more often. Flags, right? 4705.
Yeah.
Now, we don't see HOAs banning American flags, but we've seen HOAs banning political flags.
Yes.
Political flags subject to certain size and material requirements that are built into the statute are protected as well. So they fall into the same statute, okay? Now, I think it's pretty clear to say that most HOAs have rulemaking authority. And to the extent they don't, they can still pass some, the ones that are required by statute.
Yeah.
But most do. And as long as they pass them correctly, and they hit all the procedural hurdles that we talked about, and as long as those rules are reasonable, they're not capricious, they're not arbitrary, as long as those rules don't conflict with federal, state, or local laws, and are in concert with public policy,
Right.
then the rules are enforceable.
Yes.
They just can't conflict with the CC&Rs.
Exactly.
They can expound on them, they can expand on them, and they can flesh ambiguities out.
Yes.
But they can't directly conflict. And that's the bottom line on rules. It's HOAs have the right to pass them, and HOAs do.
Yeah.
They're a part of our everyday life living in an HOA. I live in an HOA. He lives in an HOA. Most of our listeners probably live in an HOA, otherwise they wouldn't be our listeners. Okay? HOAs have rulemaking authority. It's pretty broad, but they're subject to limits that are clearly set forth in not only the Davis-Sterling Act, but also other California statutes. Okay? Now, homeowners who understand those rules, understand the basis of the rules, how they come to pass, and can differentiate when an HOA is violating the law or not, are in a much better position to protect their own rights than people that are ignorant of those things, which is why we do shows like this one. Okay? When an HOA board attempts to use rules to get around having to amend a higher governing document, you'll now learn how to recognize that. When a bad HOA attempts to violate state or federal law or local law by passing a rule against, for example, pets or solar panels, you'll understand now how to recognize that and to act on that. Okay? If you like this episode, please hit the like button. If you haven't already done so, please subscribe to the channel, HOA Hell. If you want to leave any comments, as always, we love to read those. Until next time, have a wonderful day.